Welcome everyone to Vital Talks, February 23rd, 2023. It's 2/23/23. You only get to say that once in your lifetime. So enjoy it. This talk is, we're excited to have these presenters. We're not excited about it. This is important knowledge, and Becker Law has graciously agreed to help support us by educating us on this topic, AB 1162, and we're going to get into that real quick. If you send a message into the chat box, we'll say your name and your question. If this is being recorded, but you stay to the end. Don't say, oh, it's recorded, I can come back later. Q&A is live. They're going to answer some live questions to the best of their ability. So you want to stay to the end. And the other thing, just to encourage you too, is if you are going to be on camera, or if you are going to be unmuted, that if we're able to do that, it is recorded. So you're agreeing to that if you do that, okay? The other thing is a kind of a disclaimer for all, is that these are the laws today and how it's recommended today. But if you do something months from now, or even days and weeks from now, you want to double check with your attorney. Don't have an attorney? Gosh, there's a good one here today. And we're going to begin about Vital Talks real quick. If you're not familiar with Vital Talks is the acronym that we have for CSP, California Staffing Professionals, which is V for Visionary Thinkers, I for Integrity, E for Training, A for Advocacy, and L for Leadership. And Becker Law has been a servant leader throughout this whole pandemic. They are an industry partner at CSP, have been for years. And during the pandemic, I'm never going to forget you guys, because you jumped online and we had open forums, and they gave out thousands upon thousands of dollars of information willingly and graciously, and helped people get through the pandemic. So these are really nice guys. You can see them right there, but also they're tough guys, and you don't want to be on the other side. So Martin Boresco Esquire is the leader of this section of Becker Law, and everyone else has to call him Mr. Boresco. We get to call him Marty, right, Marty?
Nobody calls me Mr. Boresco, but I like that.
Okay.
I like that you think that's the case, so that's perfect.
Well, okay, Martin Boresco, or is it just you first you come across friendly and then?
I don't know.
I
think I'm always friendly, but we'll see during the course of this. It depends on the questions, right? We'll see how it goes.
Well, you can't help it. They say, don't shoot the messenger if the messenger, you're just delivering the news, right?
True.
So without other you've begun already to show us the real Marty. So I'm going to get out of the way, and I hope you all benefit from this, and actually you should enjoy it, because information is power, and this is how you're going to overcome this. We overcome a lot of things, and in California, we're the first, we're on the front lines here in California. And even if you're not a California staffing or recruiting professional, being involved in the CSP, California Staffing Professionals, is a good idea, because we have advocacy, we have a lobby group, we have a lot of things going on in our organization that go far beyond California, and the laws that start in California seep out. So Marty, take it away.
Thank you, Michelle.
Thank you, Michelle. We appreciate it.
Mike, you want to take it over? Take over.
Sure, I'll start right here. Thank you to Michelle and everybody from CSP for inviting us to speak today. We really appreciate it. My name is Mike Bartels, and I'm the Chief Development Officer of Becker LLC. I don't know if everybody knows, but Becker LLC, we are a law firm that specializes in your industry. Marty in particular is the staffing practice leader, and we represent in excess of 150 brands across the country, with a pretty large contingency of them in California. And we represent you for the entire lifetime of your business, but whatever the questions may be, whatever the needs are, we're here for you. And we'd love to answer your questions. We'd love to work with you. And at this time, Marty, I'll turn it over to you, and you can introduce yourself and we'll jump into it.
Sure. Thanks, Mike. As Mike said, Marty Barasco, I'm the practice leader of our staffing industry group. I used to say, I guess this will date me a little bit, that I didn't pick up a pen for folks in any other industry. Now I guess I'll say I don't stroke a keyboard for folks outside this industry. So I live in this industry just like the audience here every single day. Love it, obviously, or I wouldn't be crazy enough to do that. And as Mike said, we really enjoy CSP. We have so many clients in the state of California, and as Michelle said, what happens in California happens first, and it goes everywhere else. And so it's always really important for us to stay abreast of what's going on in California, and we look forward to sharing a little bit of knowledge about the new pay transparency law for you today.
Absolutely. So Marty, let me start off with the first question. I honestly believe it's always helpful to understand the purpose of the new laws, as it provides a context for understanding the law, its mandates and impacts. Marty, what is the purpose of Senate Bill 1162?
That sounded like one of my law school professors preaching to me about knowing what the purpose of something is before you try and learn what it does. I mean, it's quite simple. I mean, California is not satisfied with the progress that it's made towards making sure that there's equal pay across genders and races and other classes of people. And this law is intended to make further progress for the state of California. And they really look at two broad goals or two themes or two hopes that they hope they can achieve through this. One, they believe by imposing these reporting requirements on large employers, that the large employers will see the data. They'll see that they may see some problems, they'll spot them, and they'll self-correct. So they're hoping that folks will see their reports when they're tracking this data, see areas where they can improve towards the goal of equal pay across genders and races, and they'll self-correct. The other thing is, obviously, it provides the state of California with a tremendous data set, and they can utilize that data set to track their progress towards the goal of equal pay, to check in on particular industries, particular jobs, particular regions of the state, and see how they're performing, and use that information to determine if they need to take further action in the future. So that's really the purpose and what they're trying to achieve with this new law.
Okay. Well, can you give me a quick summary of the changes that were made to the paid data reporting by S. Bill 1162?
Sure. In my opinion, and there's, I'm sure, plenty of other opinions out there, I think there's 6 or 7 key changes that this law makes from prior law. One is that an employer who has over 100 employees has to file a payroll employee report regardless of whether they're required to file a federal EEO-1 report. So there's no longer a tie between those two filings. Now that they also, a private employer with over 100 labor contractors, and we're going to talk about this a lot, has to file what's called a labor contractor employee report covering those contractors. 3, labor contractors, who of course are the folks on this audience, the staffing firms, they have to supply their clients or these employers with all the data necessary for those clients/employers to file the labor contractor employee report. In that report, you have to include information about the mean and median hourly rate of employment groupings. It also eliminates the option. It used to be that if you filed an EEO-1 report, you could use that to satisfy the reporting requirements that California had. That's no longer the case. If you fall within the group that must report, regardless of whether you file a federal EEO-1 report, you still have to file the applicable California report. I changed the deadline for filing reports to the second Wednesday of May each year. And not surprisingly, it authorizes the CRD to level penalties against folks who don't do their filings or don't do their filings correctly.
Yeah, there's a lot. And when you go through the FAQs, they do in particular point out and give some very good examples of staffing companies, which is probably helpful to read. But what is the difference between a payroll employee report and the labor contract employee report? So I think that's really important for parties here to understand that.
It's critical. So the payroll employee report covers reporting for a company as an employee of its own, as an employer of its own employees. So this is your internal workforce as a staffing firm, or as a client of a staffing firm. This is your internal workforce and doesn't count your contingent labor. So anybody who has 100 employees is going to have to file this report. The labor contractor employee report covers clients of staffing firms who contract with over 100 labor contractor employees, and they have to file that report.
Okay, so if a staffing company was working with a certain client and that client was using multiple staffing companies, that's where the client gets to the 100 number by adding up the different number of staffing companies in order to have to file that report?
I think it's quite complicated. So
Right, I agree.
We'll kind of get into it, but yes, there are multiple ways that they count and arrive at the 100 rule, and we can talk about that. In fact, I can talk about that right now, because there's nuances. You would think, let's just take the private employee report, right? That's the simplest report. You would think it's easy. I got 100 employees, or do I not have 100 employees? And it's as simple as that. But there's a lot of nuances actually to it. One is, are you a single employer, or are you part of an integrated enterprise? So you could be a single employer. A lot of staffing firms, a lot of companies out there have complicated corporate structures, right? They operate under more than one entity. That's a nuance, right? Are we counting the employees of the individual entities, or are we counting the employees of the entire enterprise? Another nuance is who do we count and when do we count them to get to 100? And a final nuance is, we have all different types of employees from time to time. We have full-time employees, we have part-time employees, and we have employees who are on leave. And the question is, how do you count those part-time employees, and do you count those employees on leave?
Okay. I think it's really important, Marty, to determine whether an employer is a single employer or part of an integrated enterprise. Can we elaborate a little on that, and what the definition is, and explain that a little bit better to them?
Definitely. I think that is important. Well, the one positive thing about California is, and the way they've drafted this law is it does try to respect the fact that corporate entities are supposed to be their own individual entity, and so it presumes that one corporation is one employer and a single employer, and it doesn't go out there and try and create an integrated enterprise, in every situation. So that's good news. The integrated enterprise test was laid out in a case called Laird versus Capital Cities, which is obviously ABC television owner. And the court in that California case laid out really 4 factors for determining whether or not you have an integrated enterprise or not. One is that you look at the interrelation of all the operations in the corporate structure and how much are these operations connected to one another. 2, you look at the management of the corporations, and you have common management. So if you have separate management in the entities, obviously that tends to lead towards the fact that it's separate employers for this test. If you have one set of managers who manage every company. That tends to lead to a conclusion that it's an integrated enterprise. You looked at who controls the labor relationships and the employees. Is that done through, again, common folks, or is it different folks for each entity? And finally, they look at the ownership. Is it common ownership? And where does the financial control? Are these companies financially independent, or are they financially interdependent? So it's a multi-factor test, and it was set forth, as we said, in that Laird versus Capital Cities case. Now, if you are an integrated enterprise, which is nice, you do have a choice. You can file as a single entity, or you can file separate reports for each entity. So it gives you that choice.
Yeah, this reporting is really, I think I can see where it'd be complicated for staffing owners. I didn't, by reading all this and doing the research, there's a magic number of 100. What employees count in determining whether you do have 100 employees or not?
Yeah, this is interesting, and Michelle kind of brought up this theme, and I'm probably going to reiterate it a couple of times. This is where folks who are not primarily in California and think they're not California staffing firms get trapped, okay? Because the easy test is, you need 100 employees, but if you have one in California, so if you have 99 employees outside of California and one in California, you have to report. Folks need to know that. And if the one is in Nevada, but is teleworking for a company in California, that's a California employee. And again, you have to report. So, it's a little bit trickier than, how many employees do I have? And I have to have 100 in California. Nope. You need 100 employees. If one is California physically or teleworks to a California establishment, you've got to report. You also have to count your part-time workers. So, and unlike kind of the ACA, where you figured out how many hours the worker worked, and then you figured out how many part-time workers were equivalent of one employee, one part-time worker, regardless of whether they work 5 hours, 10 hours, 20 hours, 25 hours, counts as one employee. You also have to count your employees on leave. So a little trickier than just, do I have 100 employees? You have to go through that analysis to determine if you must file the payroll report.
Yeah, it's a pretty complex calculation, it seems like, with the 100. So Marty, employer headcount could fluctuate quite significantly over the course of a year. For many reasons, when do you count the employees to determine if it's 100 or more?
That's a great point. And we know with clients in our industry have great fluctuation. So it's a great question. There's really two ways you count. There's something called the snapshot period. And I think we'll talk about that a little bit more, but that's a payroll period that you select as somebody who has to report. And if you have 100 employees during that snapshot period, then you're required to report. But that's not the only test, because if you don't have 100 employees during that snapshot period, but during the rest of the year you regularly employ 100 employees, you still have to report.
Okay. Now that we jumped into it, the snapshot period seems so critically important based on dates and timing. Give us an overview of what the snapshot period looks like.
Sure. So the folks who have to report, whether it be the staffing firm has to do its own payroll employee report because it employs over 100 people, or the client of the staffing firm, whoever has to report gets to pick a snapshot period, and that is any single pay period that occurs between October 1 and December 31 of each year. So you get to pick what pay period within that time frame is going to be your snapshot period. The snapshot period then is important, as we just discussed, for determining whether you have 100 employees. It's also even more important than that It's important because the snapshot period defines the employees that you have to report about. So you don't have to report about employees who weren't employed by you during that period, unless they're on leave, then you still have to report. But those employees who appear during that snapshot period are the ones that you're going to provide all the payroll data and the information about.
Now at year end, Marty, say during the snapshot period that you pick out, because you do get to pick that yourself. What if the employee is not employed at year end, but they worked during that period? That counts towards the 100, correct?
So I think there's two things that are important about that, Mike. Yes, one, if they were employed or on leave during the snapshot period, then you have to report about them, and you have to report about them regardless of whether they leave the company, after the snapshot period. So when you go to, let's say you pick a time period, let's say your pay period is twice a month. So you pick October 1 to October 15th as your snapshot period. Employee X is a contingent worker who's out working for your client during that time period, but come November 10th, their assignment has ended and they're no longer with the company. That doesn't matter, because they were there during the period. You still have to report the data about them in your report.
Okay. So let me see if I understand this correctly. If you have 100 or more employees during the snapshot period, you have to report. What if you don't have 100 during the snapshot period, but do during other times in a year? And is there an example you can give for that so we can better understand it?
Yes. So as I indicated, I think a few minutes ago, the first place you look to determine is 100 employees is the snapshot period, but that's not the only place you look. You have to look at whether the company regularly employs 100 or more people. So the question is, what does regularly mean? And the CRD has indicated that you have to look at the business, and you have to look at what the business does. You have to account for seasonality, and you determine whether they regularly employ over 100 people by doing that. So let me give an extreme example that I think highlights this. Say you're a staffing firm and your niche is that you supply lifeguards and other employees to beach towns in the summer, right? So when would be the test of whether or not you have 100 employees? It would be during those summer months. So if in May, June, July, and August, you regularly have over 100 employees, you're going to be considered a company that has 100 or more employees, regardless of the fact that you might drop down to 2, 3, 4, 5 employees for 7 months of the year. So you have to look at the nature of the business to determine what regular is. If during the regular business they have over 100 employees, then they're going to be required to report.
Okay, well, let's talk about the data that's actually inside the report. What employees do employers are they required to report on now?
Sure. So it's all the California employees in the snapshot period. Again, this isn't quite as simple as it sounds, but it includes all employees obviously physically working in California, and it includes all employees assigned to a California establishment. So that would be teleworkers who, really report to a office in Riverside, California, but work in Nevada, and they telework in. So they would be considered a California employee, and all of those people who are employed during the snapshot period are who you're going to report on. All
right. I think it would be helpful if we took a deep dive and just, gave a couple of examples of how that may work.
Sure. I think I can cover most of the nuances in two. So let's go with two examples. All right, I'll keep a simple one. You've got a California company that has one office in California. They have 100 employees. 90 go to work regularly at that office, and 10 telework from outside of California. In that case, you've got a California establishment, and all 100 employees would be considered California employees, and you'd be required to report on all 100 employees. So those 10 teleworkers, it doesn't matter if they're in New Jersey, Texas, Minnesota, you've got one office in California. Those folks, for purposes of this law, are considered Californian employees, and you must report on them.
Okay.
Now, let's take a little bit more complicated example, and this can get obviously incredibly complicated, but let's say you've got an office in California, so that's a California establishment. Establishment is the defined term under the law, because not everyone's an office. It could be some other type of setting that folks report to. So you have one California office and one Texas office. So that would be a Texas establishment and a California establishment. Let's say, again, you have 100 employees assigned to the California office, and 5 of those telework from other states, but they're assigned to and report basically to that California office. And you have 50 employees assigned to the Texas establishment. 5 of those employees telework from California to that Texas establishment. So they're assigned to that Texas establishment. That's who they report for. That's who they get assignments from, but they're teleworking from California. So I imagine you can guess the outcome of this. California is going to grab as many of these people into reporting as they can. So again, all 100 from the California office, the 95 that go to the office, and the 5 that telework, you got to report on those. You don't have to.
Go ahead, Marty. I'm sorry.
You don't have to report on the 45 people who work for the Texas office, except you have to report for the 5 who telework from California.
All right, this is a little bit of a, I think it's an easy question, but I have to ask is, what if an employee was employed during the snapshot period, but no longer works for the employer or is on leave when the file reports?
Yeah, so I think we talked, I may have jumped the gun before. I think I answered, if they leave, you still have to report on them. If they're
Right.
there in a snapshot period, you have to report on them. And if they're on leave, you still have to report on them. So
Okay.
anybody, that snapshot period, like I said, that's why it's so important. It determines who you report on, who you give data about.
Okay. And now, does a labor contractor or a staffing firm have to file a payroll employee report?
Yes, absolutely. Why? Because a staffing firm is an employer, right? I mean, just because its clients may also be reporting data on its contingent workforce under the contractor employee report doesn't absolve the staffing firm from having to file its own payroll employee report if it has the 100 employees. So they do. So what does that mean? That means staffing firms have 2 burdens under this law. If they have over 100 employees, they are going to be filing their own payroll employee report. And if they are providing contingent workers to a client who has over 100 contingent workers, and there's one nuance to that we'll get into, but who has over 100 contingent workers, then they're required to supply that client with all the information necessary for that client to file its labor contractor report.
Okay. Is the test for determining whether an employer contracts with 100 labor contractors employees different than the test determining whether there are 100 employees?
Well, it's pretty similar. All those kind of examples that we gave for employees versus labor contractors are all the same. So if a labor contractor works in Nevada but teleworks into California, they're going to count as a California labor contractor. If the contingent worker works in California but for a Texas company and teleworks to the Texas, they're still going to count as a California labor contractor. So all of those rules and the examples I gave before, they apply the same to determining if one of your clients has 100 labor contractors. What's different, and unfortunately, is not as big a loophole or exception as I would have hoped. What's different is that the labor contract employees, to be counted, have to be provided to the client to provide labor that's within the client's usual course of business. So let me repeat that again, because that's quite a few words and it's really important. So there is a test, unlike an employee is an employee for the payroll report. For the labor contracting report, you have to look if the contingent worker is performing labor that is related to the client's usual course of business.
Okay. So on the surface, it sounds like that's a major difference and would help limit the number of labor contractors, employees that count. Am I correct about that?
It's not that, it turns out not to be that major of a difference, and not that much assistance to pull contingent workers outside of the definition, because of the way that California is interpreting usual course of business, and what is the regular and customary work of the employer or the client in this case. The definition that they've supplied, I just want to read it out, is regular and customary work is work that is performed on a regular or routine basis that is either a part of the client's customary business or necessary for maintenance and preservation of that business. So the first part, makes sense, and if they had stopped there, we might have been able to pull out a lot of the contingent workforce, and that is it part of the customer's business, right? So if the company, is a manufacturer and it makes things, and the labor contractor is helping them make those things, well, that's clearly part of the business, right? If it's a retail shop and it sells things, and the labor contractor is part of that process of them selling things, same thing. So that's pretty easy. But where they really almost bring every contingent worker into the equation is with this necessary for the maintenance and preservation of the business part. And what they've said is that this really captures any administrative functions within the company that the company needs to perform on a regular basis to keep its operations flowing, right? So accounting, right? That would be considered part of the maintenance and the preservation of the company's business. HR personnel, part of the company's maintenance and preservation. IT professionals, for the most part, are going to be part of the company's maintenance and preservation. So all of the administrative operations that support the company's business, if you're supplying contingent workers for those operations, they count. So what does that leave? I mean, does that even leave anything that would leave a contingent worker out of the mix and not be counted? And it really only provides room in what would be called one-time or isolated assignments. So a prime example of a one-time assignment might be that the company's gonna plan a retreat each year, and it's gonna bring in a bunch of contingent workers to help staff that retreat. Well, in that case, the contingent workers wouldn't be considered part of the usual business of the company, and they wouldn't count towards the 100 employees. So what might be another example, if you do some type of special audit, right? You bring in external accountants to do a special audit, or you bring in professionals to help you with a one-time special project. That probably wouldn't count, but that's it. It's very isolated tasks or one-time tasks. That's the only exception.
Okay, well, we did some research together, and I wanted to touch a little bit about the reporting methods, Marty.
Sure.
There's typically 3. The CRD's template allows you to, they have an entire instruction booklet and an Excel file that you can use. They also have a CSV file using the instructions in their guide to the portal. And they also have the portable fillable forms. You and I both know the extent of this. We went through this with PPP of the different forms you had to work. How important it is for our audience today to really work with their accounting firms to ensure that they're capturing the data that they're looking for.
Look, this is quite a burden on folks in our industry. And as we discussed, it's a two-way burden, right? You've got to probably, most staffing firms are going to hit the 100. And, you know, so they're going to have their own payroll employee report to file. And many are going to be doing business with clients who hit 100. And so therefore, they're going to have to supply these clients with all of the necessary data. So what does that mean? I mean, that means you're going to have probably a combination of folks. Larger industry clients might be able to have the expertise and all within the, you know, their office. But it's a combination of accounting and HR expertise that you're going to need here to successfully fill out these reports. You know, so you're going to need to have some combination of internal folks who can help you do this and external folks.
And it seems like the penalties for this are going to be pretty stringent on this. I guess it's the first time failure to report penalties can be up to $100 per employee, and they can further increase to $200 per employee. It seems like they're going to be very strict about this.
Yes. And, you know, you can, I'm not great at math. That's why I'm a lawyer, but you can multiply 100 times the number of employees you have and probably see the number, and you can multiply 200 times the number of employees you have and see the number, and that it can go up really fast. And the thing about that penalty is the CRD has indicated that if you are a labor contractor who has supplied labor contract employees to a employer who doesn't file their reports correctly, doesn't file them or just doesn't file them correctly, because you have that requirement to provide them with all the information necessary for them to file the report, the CRD can come in and proportionally assess part of the fee that has to be paid by your client for failing to report to you as the staffing firm. So again, you've got this dual obligation as a staffing firm, and the penalties apply to both obligations.
Yeah, and I also just read something else, Marty. It was pretty interesting. Who can certify the employer's paid data report? PEOs, HROs, and labor contractors may assist in helping prepare and may file paid data reports with CRD on behalf of client employers. An official of one of the client employer, not from the PEO, HRO, or labor contractor, must certify this report. So it really does fall in the onus of responsibility falls on, you know, in this case, the staffing company.
Again, the staffing company is going to have that obligation probably of filing their own payroll report, and you have to have somebody certify to it. You know, that's how the government puts teeth on it, is that you're going to swear to the accuracy of this information, and it's going to put obligations on the person that does it. There's rules about who can do that, right? You know, so, you know, it's got to be people who have knowledge and are familiar with the data and familiar with what data has to be produced, familiar with the employment of these folks. So, you know, it's quite a responsibility anytime you're signing these reports, and the staffing firms and other employers obviously are going to have to pick the right people to certify to these.
Correct. Well, that's all the questions I have for you today, Marty. Do you have anything you want to finish with?
Yeah, I've got a handful of other topics, you know, that I'd like to talk about. You know, and I think I'd like to elaborate on this a little bit. You know, what is important is for staffing firms to understand what data is required for their clients to fulfill their reports, right? So you need to be familiar with those reports so that you know what data is necessary to be supplied to those clients. Another thing, kind of a best practice that I want to talk about is, how do you know if your client has over 100 labor contractors, right? Because you might be supplying IT, right? And a large employee might have folks in accounting, or they might have folks in admin and secretarial that they're hiring from other labor contractors. So it might not be obvious, right, whether or not your client has over 100 labor contractors. So what should you do, given that if you don't supply the information, you could be assessed the penalties? So a lot of folks have said, okay, well, it's incumbent on the client to tell you. Maybe, certainly in a situation that's less obvious, maybe the client has some burden, and I'm sure the CRD would slap the hands or fine a client who, doesn't provide the information. But probably the best policy to undertake is to ask. I mean, asking your client if they meet the threshold and have to report would seem to absolve a staffing firm from any issues if the client doesn't report, should have reported, and you didn't provide the data. So I think that that's a really important element. I know we've had clients who've already seen changes in their contracts, right, regarding this information, right? Changes in responsibilities to provide this information being imposed by clients, changes in indemnification obligations regarding this information, policies being set as to what does your client do with this data, right? You're handing over to them a bunch of data about employees. What are their obligations with respect to that data? So, as usual with these new laws, there's not just compliance with the laws, there's these ripple effects that staffing firms have to think about in terms of expecting that their clients are going to be contracting with them a little bit differently, wondering if they should be making changes in their home contract regarding this, right? Should there be some changes in this? One change, for example, that we've been recommending to clients is to force the client to have to tell you if they have to report, right? Part of their contractual requirement is telling you that they have to report. And if they don't tell you, then you get indemnification. So there's some changes that folks might want to think about in their contracts. One thing that we've got a lot of questions about is kind of the VMS MSP situation. Who has the obligation to file and provide the data? Okay. Does a VMS or an MSP have to file a labor contractor employee report, right? Because all of the contingent workforce has been centralized in one fashion or another under that VMS or MSP. So those are interesting questions, and I'd like to take a second or two to talk about those. The latter one, right? Does an MSP or a VMS have to file a labor contractor report along with the employee, with the client, the ultimate client? The answer is no. The VMS and MSP does not have to file a labor contractor report. Only the end client, who is ultimately receiving those services from the contingent workforce, has to file that report. So that's helpful with respect to our industry. But let's talk about the situation, because I'm sure many folks on this are supplying contingent workers through a VMS or an MSP program, and they've got a group of their contingent workers in the program, and then other staffing firms have groups of their workers in the program. The question is, who has the obligation to provide the necessary information to the end client? And the answer is both. And the answer is also that you can't just combine that data. The MSP and the VMS can't just centralize and combine the data and provide it. So if you're part of a MSP or VMS program, you're supplying 10 workers through that program, you're going to have to provide the data on those 10 workers that's required for the labor contractor employee report. Again, if you don't provide that, then you're going to be subject, if the employer doesn't, your end client doesn't file the report, you're going to be subject to potential penalties. So those are some of the nuances. There's obviously a lot of complication of what goes into these reports. How do you calculate the mean and the median hourly wage? Has some complication. Those are going to be the things that, Mike, to your point, that you're going to either want to have internal employees who understand how those calculations work, or you're going to want to work probably with an outside accounting firm who understands how those calculations work. There's some complication to it. You also report in what's called employee groupings, right? So the idea, obviously, of the law is we want to track pay across gender and races within classifications of work, right? And so those are called employee groupings. And there's quite a bit of complication with respect to defining what an employee grouping is, right? So that's, what data do you need to assemble within a certain group? Who's in this group? Who's in this group? That's critical, because if you're putting people in the wrong group and there's pay disparity, right? Then the problem is existing. So you want to really make sure you understand what the definition of employee groupings is, and that you have internal personnel who understand what employee groupings are. And then the last thing, and that's not really part of the pay transparency law aspect of this, and I know that's what this webinar is about, but there were also changes with respect to posting pay scales that came along with this, that were part of the Equal Pay Act. And that applies to a much smaller, has much smaller reach. It's 100 for this, but it's 15 employees that have to post pay scales now under a bunch of new regulations. So I'm sure most of the staffing firms are aware of these rules. But if you're not, there's a great set of FAQs under the California Equal Pay Act. I believe it's the DRI that published those FAQs, and those FAQs are very, very helpful in helping you understand if the law applies to you, if the law does apply to you, what do you have to do to kind of comply with the law. So not a pay transparency data issue, but it is part of this bill that passed, and is something that clearly, the law clearly says that it's applicable to staffing firms, both folks doing permanent recruiting and folks doing contingent recruiting. So, but I think that's a good, not only high level, but a little bit of a dive into a bunch of the issues here. I'm happy to answer some questions if any folks in the audience have questions.
Just use the chat if you have any questions, please. You can shoot them out to us, or you can email us later on as well. Our contact information is up on this last slide. Michelle? Thank you so much. Thank you, everybody at CSP for today. We really appreciate it.
Just one more thing,
If we
Mike.
have some questions, we definitely do. So,
Well, yeah,
Um,
and if we don't, as always, Michelle, to be a good participant in CSP, we're willing to talk to some folks on our own dime. This is a important new law. It's got some complexities to it. We didn't really touch on, like I said, the mean and median and employee groupings, because that's pretty complex and I think a little too far in the weeds for this. But we're happy to spend 20 minutes on the phone with folks if they want to reach out to Mike and answer some questions. Either I can jump on the phone or most folks know Chris Letty of our office who helps us in this area so much. Chris can jump on the phone and answer some questions as well. So they should feel free to reach out, and happy to spend a little bit of time to help them navigate these issues.
and you've always been so generous about that. And that is part of at the end. I want to remind people that too. We're not at the end yet because we do have some questions. Okay, real quick. And some of them you already answered, but if folks who put their questions in don't feel like their questions were addressed, you could kind of resend them. But we answered the question about whether the staffing company is required to reach out to clients and confirm the 100. They have to try, and you recommended that we put it into our new contracts. If we
Yeah,
have
they don't have to. So there's no
Yeah.
obligation that you have to. But the
Ooh,
question is that's asked is, should you have known that your client had 100 employees? So my question is, how do you know if you should have known, right? The easiest way to say, to answer that question is, should have I known? Well, I asked, right? So if they say yes, then I know. If they say no, then how should have I known they were wrong about telling me no? So you're not required to ask. I just think it's a best practice to ask, because like I said, you might be supplying IT and not realizing that they've got a bunch of other folks that are being supplied by other folks.
well, and then also when people get in trouble, the company gets in trouble itself. They're first thing they're gonna do is they're gonna kind of try and bring in some help and say, well,
That's
my
right.
staff.
That's
So
right.
that's something good to remember. And then as far as one person had asked about, do we report our out-of-state employees or only the California employees? You answered that. You answered that, how we report them. And
That's right. We do not report all employees count to determining whether you're required to file a report, but you only report on California employees.
well, I have a new one that
Right.
I was jotting down. I was writing furiously. Okay, so so this starts January 23rd, 2023, right? So the snapshot period, or does it encapsulate last year too when we start that snapshot period? Because our first report is due this second week of May in 2023, right?
The first report is due the second week of May of 2023, correct? And your snapshot period will be somewhere between October 1 and December 31st of 2022.
Okay, so you got that October 1 and December 31st of 2022. That's when the clock starts. Okay.
Right. And so with staffing firms, this can get complicated too. And I didn't want to touch on it, but I think it
Okay.
makes sense. You could have two different payroll periods, right? Some staffing firms have a payroll period for their internal employees and a different payroll period for their contingent workforce. So when you have your snapshot, you're picking one payroll period, but all your employees within the snapshot of your other payroll period are also going to be counted in there. So it's a little complicated when you have multiple payroll periods, and probably again, make sure you have somebody who understands how the multiple payroll periods work and that you're doing it right.
Marty, Mike, let me answer your question in regards to that. So, maybe a staffing firm does a weekly, bi-weekly, and then other people monthly. So do you take the longest pay period and work it backwards for that? So you would take the monthly, then incorporate the bi-weekly and weekly?
The CRD hasn't mandated that you pick the longer pay period if you have multiple pay periods. So you still have the choice of what pay period you're gonna pick. Just understand that the employees from the other pay period are still gonna count as folks you have to report on. And they're obviously still gonna count in your total employees in determining whether you have 100 employees.
Got
So
it.
then as a safety net, you'd be better off doing it as for the monthly if you had all three, then incorporating all of your employees into one.
Probably.
Okay.
Okay, more questions because I know we're running out of time. Very good question here. Is the data that's reported publicly available to attorneys who may be looking for lawsuits?
No, that was something that is fantastic. It is protected. It cannot be obtained under a public records request. So unless there's hacking into the California system, it cannot be obtained. And California has obviously a very good system for protecting their data. So be very unlikely that it gets hacked. So that's one positive thing about this. This data will not go out to plaintiffs' lawyers who love to start class actions.
Great, that is good news. So we had some good news today, guys. And then as far as the tables, where do we find those tables? I don't know. Forgive me if I missed that. I see that in the questions, but that was on my question list as well.
Mike? You
Oh,
looked
that's
at-
right. You go to the exact website that Marty was talking about before.
The DIR.
Yeah, do go into there and they're gonna still, and also if you there and type in SB 1162, they'll show you where that data is, where you can find those questions that need to be answered and the the Excel that you can put it into.
Yeah, I think the CDR has it as well.
Yes, correct.
Okay, well, everyone take note of those addresses and we'll go back, but what we're going to do is we're going to flip back to the slide at the end real quick. We've got some goodies to announce, some really important things. Just real quick, stay with us. May 10th through 12th, we have the San Diego Bayside, we have the CSP annual conference. And if you've never been to conference, and if you're not in California, it's a good reason to come. But also, so much networking, so much business that gets done, so much information. And we have experts like Becker Law that come and present there. And so the presenting list is still in the works. We've got excellent speakers, and it is fantastic. So put that on your calendar. And you want to register before Wednesday, March 1st to take advantage of early bird rate. And then, all speaking of early bird rates, we also have an early bird rate for the accommodation. And it's on Bayside, so you have ocean views and ocean breezes. And you need that when you're dealing with all of this stressful stuff, right? So the next slide will have upcoming events that we have. We have upcoming events we have in March. We have a CSP. It's going to be all about how to supercharge your staffing. And that's not on the slide. Unfortunately, I didn't make it in the slides, but that is important. So for March, to be determined the date, we're still working on that with the speaker. And we'll get back to you on that. And then April, we have a wonderful presentation planned on how to level up your staffing and recruiting and marketing. And that's going to be April 20th. We do have that date. And there's a bunch of other events coming, and you can see those dates there. There's so many: May, July, September, November, and more. There's more. We're always adding. We have a podcast. Please go and look it up. We were in the top 50 podcasts for our industry. So please go to our podcast and listen to them. It's free. Download it from wherever you go, or just you can go right onto these, click these links right here, and away you go. So I'm going to go back to, so the goodies are, you can save a lot of money at conference. And then let's go back to the slides. These gentlemen here, Michael Bartels and Marty. Now, is it better to reach out to you? I don't mean to point at you. I just realized I'm pointing. Is it better to reach out to you, Marty, directly, or would you prefer people reach out to Michael? Or we don't have your other staff members on here, but
Probably Michael is best because he can figure out whether Chris or I are available, or particularly there's some questions that are probably Chris has more expertise on than me, and vice versa. So Michael's really good at quarterbacking that.
Okay, great. And so write down both numbers, or you can get these slides too because you attended, and you can reach out. And like they generously offered. The clock doesn't start in just a simple discussion for the first few minutes there. You can call them, you can ask them questions. Then they can kind of tell you if you need to go further. And you know, obviously you get your legal advice from your attorney, but they're happy to provide some information. We're just so grateful for you. You have been so wonderful, Becker Law, Michael and Marty. Just thank you so much. We couldn't be CSP without you.
Oh, thank you.
And CSP has been doing what other people are thinking about doing now. I mean, we lead our industry in a lot of ideas and things that we do. We hope people that are considering joining CSP join us or keep on coming to our meetings. And we hope you come back, Marty. We hope you come back.
We love the opportunity to talk to folks in our industry. So anytime, Michelle, really appreciate the opportunity.
Awesome. Thank you. All right. Well, I
Thank
think
you.
that today, and thank you for joining us today on Vital. Bye-bye.
Good day, everybody.